All right, so let's get started. Welcome to this first CodeX Speaker Series event in 2015. My name is Ron Vogel. I'm Executive Director of CodeX. CodeX is the Stanford Center for Legal Informatics. We are a joint center between the Stanford Computer Science Department and Stanford Law School. Our motto is legal empowerment through information technology. So we are researching and developing technologies that make the legal system more efficient for all stakeholders in the legal system. So thank you all for coming. Before I introduce our speaker today, a quick announcement. So CodeX typically meets every week, normally every Thursday at 1:30 in room N102 in the Newcomb building. And we always have interesting speakers coming in, legal tech startups, pitching their companies, academics presenting their ideas and insights. So you're all welcome to come to these meetings. You can sign up for our group on the CodeX website at codex.stanford.edu. Next week, the meeting will actually not be happening because we're going to be at Legal Tech New York. Legal Tech is really the biggest trade show in legal technology. There are going to be about 12,000 people at this conference, and we were actually invited to develop a whole track at this conference, and they gave us a pavilion for 10 early stage interesting legal tech startups. So if you're in New York next week, next Thursday, come to the CodeX Pavilion and to our educational sessions. Okay, so with that brief introduction, it's my great pleasure and honor to introduce to you Professor John O. McGinnis, our first speaker this year. Professor McGinnis is a very accomplished constitutional law scholar. He's now focusing much of his work on legal technology and the impact of legal technology on the legal profession and the legal system more broadly. He is his official title is the George C. Dix Professor in Constitutional Law at Northwestern University. He's a prolific author. With over 90 journal publications and also some books that are very interesting for folks interested in law and technology, including the book Accelerating Democracy, Transforming Government through Technology. So he's went to his undergrad and law school. His law school degrees from Harvard Law School, and he also studied philosophy and theology at Oxford. He has a master's from Oxford. Okay, so there's obviously much more to say about you, an accomplished scholar like Professor McGinnis, but I don't want to bore the audience too much with my descriptions here. Rather, I'll turn it over to you. Professor McGinnis will be talking about computational jurisprudence and share with us some of the ideas he's developed in his recent paper that's titled The Great Disruption, How Machine Intelligence Will Transform the Role of Lawyers in the Delivery of Legal Services. So,
thank you very much. Well, I'm delighted to be here to talk about the Great Disruption, because there could be no better place to talk about it, because the disruption is coming largely from Silicon Valley and places like it across the nation, not only in law, but in other areas, as more and more domains of social life are thrown into the vessel of computation and its acceleration. I'm going to talk today about the disruption in several respects to the legal profession, but I'm also going to end by talking about another one of my papers, Law as Algorithm, to suggest that the disruption is not only about what will happen to the legal profession, but into the nature of legal jurisprudence. It really has some impact on the content and the style of law that we may see in the years ahead. And so I'll simply begin, and at the risk of boring a knowledgeable audience, a bit about what are the causes of that disruption, because then I draw two propositions that I think are important for predicting the course of the disruption in the legal profession. I will not spend a lot of time with this audience on discussing the exponential change in computation. I'm sure most people here are familiar with Moore's law, the idea that the number of transistors on a silicon chip doubles every 18 months, and the sense more generally that computational power is doubling both in its computational power and its memory at about from 18 months to 2 months, to 2 years. And that really, that exponential rate of change leads to a technological acceleration. I would just say two things about that, to say that in some ways that understates, I think, the exponential power of computation, because two other things are happening as well as changes in hardware. One is that there are changes in software. Software is also improving quite apart from the improvements in hardware. And connectivity is improving. The internet, obviously, is an example of that. And that is not changing, that is not stopping. There's obviously going to be an Internet of Things, more and more people connected to the internet in a stronger way. All of those are force multipliers for the power of computation. And I think the best way of understanding that in at least an anecdotal sense is to understand the difference between the change that happened between the mark of Big Blue beating the best chess player in the world, Garry Kasparov, in 1998. That was, of course, a great benchmark for the power of computation, showing that chess was fully in that domain. But of course, chess is an extremely formal system. You might not think that has a lot of implications for much of our social life. But only 13 or so years afterwards, Watson machine won at Jeopardy. And again, I don't think I need to explain what Jeopardy is. It's a game of general knowledge. It beat the best Jeopardy players in the world. And it did so because of advances in all three aspects that I have mentioned. There were obviously advances in hardware as Moore's law continued to pace, but there were advantages in software. What Watson did was had a lot of different algorithms working all simultaneously. And connectivity was also very important to Watson's triumph. Before it played the game, it connected to the internet and got all of that information with which it could beat the best Jeopardy players in the world. So I think take two general propositions from this. One is that, computers move and put more and more of the domains of our life into the vessel of computation. And they move from very formal systems to less formal systems that seem to be a little bit more, for instance, like law. The second proposition is that once computation gets into a domain of life, it starts to move very quickly. For a long time, computation really doesn't have any effect or doesn't have any substantial effect on the practitioners in an area. But then once it gets into the domain, it makes rapid progress and can dominate often the domain. I have an example of that from my own life. When I was in high school, I was not a bad chess player, and I could beat the best computer at chess. Now I am humiliated on a regular basis by my smartphone. So that, if that is the story, that's a very important story, I think, about why we should imagine a great disruption. Because what I'm now going to describe very briefly is how machines are coming to law, some of them, I think, already disrupting in aspects of legal practice, but all either in or about to, or how we can see a path to their at least becoming part of that, legal practice. And once they become part of it, they're going to get better. So let me begin. I'll talk about 5 areas. One, which is already substantially advanced, is document production. Again, I can make this personal. When I was a young associate at a New York law firm, I was put into a room and spent weeks going through documents. Anyone who knew me would know that was a very bad use of my time. It was boring. You had to be in charge of filing, keeping the documents in certain orders and things. Now, of course, that kind of job is going to be, as I would put it, machined away. We can have algorithms that can predict what is relevant, and already there's some suggestion that they're better than humans. It doesn't surprise me they're better, and once they get into this field, they're going to be going to dominate it. After all, they don't need caffeine or sleep, so they'll move very rapidly to dominate, I think, the finding legal documents. And they even can be told about issues like legal privilege. Word queues can figure that. Now, they're not going to be perfect, but remember me. I was far from perfect in discovering those documents. And parenthetically, I would say this is actually important implications for justice. One advantage for it is a tremendous problem in document discovery in that you're asking the opponent to discover the documents. That's a huge agency cost. But what these machines allow us to do is to have the lawyers agree on the algorithm, and that, I think, is going to substantially reduce those agency costs. And so I think it's actually a not only efficient, but it's a move towards justice. So I think that's the most advanced thing we see in document discovery. Legal search, of course, legal search, computerized legal search has been going on for some time, but it's obviously improving dramatically. It's improving in cost. Now one really doesn't need LexisNexis to search for a lot of documents, so it's one way to think, of course, of computation is that it makes things not only faster, but it makes things cheaper, and we see that as well. But also the nature of legal search we can predict is going to change by looking at Watson. Watson is able to do much more substantial semantic search. In other words, what we do now, largely, or what we have done with legal search, is simply search for keywords. But that isn't really what law is about. It's about semantic concepts. And what we can predict is that legal search is going to be better at finding semantic concepts. So we're not just going to be we can look for things not only like a boat. We can understand anything that's moving in the sea can be captured by legal search. And some legal concepts can be better captured by the kind of search that Watson came up with. And we're already seeing substantial improvement in legal search and startups in this area, giving some sense of what cases have actually influenced the law with network analysis. And so I think it's not too far in the distant future. We're likely to have search be able to help people with choosing cases, even for particular courts, what cases seem to win in particular areas. I'll come back to legal search at the end of my talk because I think this also has substantial jurisprudential implications. Another area of law that I think we're likely to see, we're already seeing disrupted, is the law depending on transactional documents. We see that with respect to LegalZoom, simple wills. One way of thinking about this is really TurboTax coming to law. Simple transactional documents have relatively few inputs in them, and one can see the practice being machined away as people essentially use what was the equivalent of using legal forms, but in a much more sophisticated way, which asks all of the relevant questions to them and puts that in a document. Indeed, I think it is likely that within a decade, no one really except centimillionaires will have much need for lawyers to draw up wills. for instance, I think that's an area of legal practice substantially at risk. The next area I think is somewhat farther away, and that's the writing of legal briefs. Although I think we will see that within a decade or two, at least simple drafts of legal briefs that then can be worked up by lawyers. Because remember, always technology, or often technology, comes in with very simple and cheap aspects and then moves up the food chain, so to speak. I come from an institution, Northwestern, where its AI department has already a very significant spin-off in the writing department. There is something called narrative science, which right now is a threat to at least simple journalism, that is writing stories about financial earnings, also writing stories about sports. And while it's not perhaps yet Ernest Hemingway, it is completely readable, completely workable, and I see no reason that that kind of machine can't come to law. If you ask me where I think it might begin, well, let's think about the IRS. The IRS does a lot of litigation with taxpayers. A lot of it's relatively simple litigation, repetitive litigation. They have an enormous number of briefs on file. I'm sure what happens at the moment is lawyers mark up those briefs. And I think that is certainly something that could be computerized. So I think, again, what we're likely to see is not a threat, obviously, to the Supreme Court practice, but at the low end, I think we are likely to see that as well. Fifth, I think the area is what I would call predictive legal analytics. One way of describing that is Moneyball is going to come to law. You'll remember Moneyball, which was the way in which some people with more analytic skills beat out scouts with their more intuitions about who was to be on the team. And that's how the Oakland A's improved as a team. Well, similarly, a lot of what lawyers do is they predict things. They predict, well, what is the likely outcome of this case going to be? Should we bring this suit? Is this patent challengeable? And they actually, of course, predict that on the basis of their own personal information. And one can well imagine that for the same reason the scouts didn't do as well as a more analytic way of looking at a broader range of data, computers are likely to do better, or at least likely to substantially supplement human activity in this area. And I think that's for another reason. I think they may bring a greater dispassion to prediction, because I dare say that one reason lawyers predict that they're going to do well in a case is they're the lawyer. And that is something that is substantially has to be doubted, I think. There's a substantial bias there. Indeed, one thing I think is which is very close to legal predictions, which is already happening, is better evaluation of lawyers, trying to look at their win-loss records, but trying to put it in context of the difficulty of the case. I think we're likely to see that. And that's really helping you predict what lawyer you should choose. So I think that's another aspect of this prediction. Well, now what have I described in this great disruption? I've described document discovery, legal search, transactional documents, legal briefs, and prediction. Well, I seem to have described most of law as subject to disruption. Now, you might think that some portions, I think, are unlikely to be disrupted soon, being a courtroom lawyer, unlikely to be disrupted. But even that could have an effect. I mean, let's think about if we actually have better predictions about the value of cases, what we would think is that there's going to be less litigation and more settlement as people converge on the value of cases. So all of this strikes me as a huge threat, and a threat, as I think, is a somewhat imminent threat for the reasons I've suggested to the practice of law as it is done. Now, I want to be clear, this doesn't mean it's going to happen tomorrow. It's going to happen over time in the next 2 or 3 decades. But already I think it's something that lawyers and certainly any law student should take account of. And what do I think it's because I do not think one idea would be the legal profession can prevent this from happening. I mean, guilds throughout history have tried to prevent innovation. I think this is very unlikely to succeed with the innovation coming through computation for two reasons. One is many of these that I've described can be used as inputs into traditional lawyering. You can have simply a lawyer look over a transactional document. Nevertheless, that will still substitute substantially for lawyer time and lower legal costs. Another reason is that jurisdiction will be very hard to prevent jurisdictions outside of the control of the lawyer's jurisdiction from having these machines. They could be anywhere. How is the bar going to prevent them from being used? And then I think even sometimes they have tried to go against LegalZoom in places like Texas, and the legislature realizes that this is an advantage to consumers and pushes back. So for all of those reasons, I do not think regulation will succeed against preventing this disruption. So what are its long-term effects likely to be for the legal profession? I think one thing is that this is generally true with technology. Superstars will be helped. Technology will extend the reach of very successful lawyers. I think already we're seeing the associate to partner ratio change in law firms. I think that's likely to continue. That happens right across the effect of technology. So what I tell my students is one way of dealing with is simple. Be a superstar. Well, there's some other ways that one might think of doing it if one's not absolutely confident one's going to be a superstar. Well, I think another way of thinking about machines is that they're going to do better where the patterns of law are more static. So simple wills, for instance, that's not a good area to be in, trust and estates. On the other hand, a changing area of regulation, regulation that's always changing. I would say banking regulation would be a good example of that, where not only the regulation is changing, but new regulators come in with new administrations. That's less easy, I think, in the long term to get patterns of recognition. And so that's a good area to go into. The other thing I would point out is that lawyers do other important things other than analytics for their clients. They often persuade clients to settle when their clients think, quite wrongly, that they should go on and sue or pursue some course of action. And here, I think one has to think of the comparative advantage of humans. We still have advantages in human bonding with clients. And that's a very important aspect of it. So it may be that at least some lawyers in the future will be more successful with maybe even with less analytic skills and more bonding skills. You might think that is a possibility. The final area where I think lawyers may do well is, of course, there are a lot of unmet legal needs, particularly for poor and middle-class people. And that's one way of figuring out of how to use machine intelligence to be sort of the Walmart of law. I think there's also a lot of opportunity, at least for some lawyers. So I don't want to suggest that the sky is falling. There's not going to be any role for lawyers. Lawyers are going to remain an important social force in our society. I do think, though, that lawyers are going to have to change a bit in what they're going to focus on, and we're going to see some of the same things that have already been happening in the profession. I think a very strong bimodal distribution of lawyers. I certainly do not think technology suggests that we're going to go back to a world where the average, the journeyman lawyer does nearly as well as the superstar. So that's the effect I think we're going to see on the profession. And so I hope you'll ask and I've spoken a bit of time, but I hope you'll end, I hope I can end and ask your indulgence for, after all, this is a law school, and talk about something a little bit more theoretical about the nature, the effect of legal computation on jurisprudence. So how does one think about this? I think it may have substantial effects in a variety of ways, but let me just end very briefly to discuss a well-known debate in law between rules and standards. We think often about their advantages of using rules and their advantages of using standards. This debate has gone on throughout, not only theoretically, but throughout American history. If you go back to the 19th century, the codification debate was a lot of debate about, are we going to have rules that are written out, or are we going to let an evolving common law have standards? And there's sort of to be advantages of both. With rules, the advantage is as well, at least we think, we have some clarity, and people can know what what conduct is expected of them. Of course, a disadvantage of rules is we need a lot of information right at the beginning in the legislature to generate these rules. And sometimes we don't have that information. One of the advantages of the common law is that it takes information from the world in a variety of cases with a variety of decision makers and accumulates that information. The disadvantage is we have a lot of these decisions, all of these different points. How are we going to bring them together so people can understand their conduct? You can see that, I think, push and pull throughout the history of law. We have code books in England, and Blackstone comes and synthesizes them. We have a much larger, unruly body of cases, as in the industrial society, we have Westlaw. So that push and pull marks it. How is legal computation going to affect that? Well, I think it is substantially going to advantage standards and perhaps also something I might call dynamic rules over the usual static rules. In one way, and let me try to be brief and to the point about this by giving an example and then talking a little about it theoretically. This is an example from real life. Montana, I think around 25 years ago, decided to get rid of its speed limits. And so it said, in Montana, drive at a reasonable speed. That is a classic standard. It didn't work out so well. People didn't quite agree what a reasonable speed was on the road. There was an enormous amount of litigation. And finally, their Supreme Court struck down as unconstitutional drive at a reasonable speed, saying that it didn't give people sufficient notice. And so, of course, one could see why maybe Montana suggested drive at a reasonable speed was a sensible thing. Different places in the road, different conditions. You should drive at very different speeds that are not captured by some simple rule. Well, that was unimaginable then. Well, let's think of a world, at least maybe a world without Google cars, a world where people are still driving, but a world full of legal information. One could imagine there a way of having an app on the dashboard telling you what a reasonable speed is, accumulating where this is in the road, what the driving conditions are, and refracting that against all the previous decisions that have been made, the sort of common law decisions on what a reasonable speed has been. Notice that one now doesn't need to have the information up front because it's possible more easily to accumulate that information. And so that's the idea. Theoretically, I think the idea behind this is, I think, perhaps a powerful one. There's an idea in information theory pioneered by people like Claude Shannon about noise. And one of the problems for us in understanding law is to figure out it's rather noisy, particularly in a common law system. We have all these cases, which is cases, and that's one reason, for instance, that even legal search today is still relatively noisy. It delivers us not the case that we really want, that's on point, but just a lot of different cases around it. It's very expensive to figure out what exactly is the most relevant case. One way one can think of computation is as reducing the noise in legal search and actually giving us what's called in information theory a kind of algorithm, the shortest way of predicting or saying what the law is. And that's what I think we may ultimately move to as search becomes better. Something like law algorithm telling us what the law is in fact, what the speed limit should be at any particular time. Now notice I'm using a very positivist view of law. Holmes's definition of law, what is the law, is what the courts will do in fact, and nothing else do I mean by law. But this sort of predictive element of law, I think, is substantially advantaged by the change in computation. And that means that the Montana drive at a reasonable speed becomes a more reasonable kind of law as computation becomes more powerful. Now, there may be alternatives in this world of computation. One might think of Montana as actually putting an app on everyone's themselves on everyone's car and saying this isn't the reasonable speed. That's sort of a dynamic rule in which they're going to take information from the world and compute it themselves. So I think that's an alternative. And in the paper, I discuss the reasons to prefer one or the other. But I do think that this computation, therefore, I think, just let me end on this point. Some people, I think that why are we worried about, or why should we even think academically about computation? Isn't this just like typewriters coming in? Typewriters changed law. People type faster. But I've tried to suggest why I think that computation is going to have a much profounder effect on the legal profession. And if we think that law is itself a kind of information technology, which it ultimately is, it informs people of the standards for which we expect them. It also tries to take information from the world. It shouldn't surprise us at all that a revolution in information technology, which is what the computer is also necessarily a revolution not only in the legal profession, but in legal jurisprudence. Thank you very much.
All right, any questions for Professor McGinnis?
Hi, I'm Violetta Bueller from Chicago, and I'd like to thank you very much for your presentation. I was very interested in what you said about the superstars maybe being the ones that will survive in light of this technology revolution in the law. Taking that a step further, do you believe that in terms of law firms, the so-called superstar, perhaps larger law firms which can better afford the technology and the training will be absorbing the smaller ones? And what do you foresee in terms of law firm life in that decade or two ahead of us? Thank you.
Well, I'm not sure. One thing about technology actually is I'm not sure how expensive it always is. It becomes cheap quite quickly, so I'm not sure that's what's going to be the superstar. I think that they're going to be able, people with just who are better at other things, who are better at law, will be able to use technology rather than associates. So that's what I see as the reason I think about this. There's a famous article. My thinking on this is very informed by a famous article by Sherwin Rosen, a University of Chicago economist, who gives this wonderful example why he thinks it's called the economics of superstars. Gives this wonderful example. Well, it was a great thing to be the best string quartet within 50 miles in the 19th century. Not so good when the CDs come in. And so that, I think, is the problem, that there's going to be a kind of reach. But what I would say is that the biggest change that I think might happen in the legal profession, because of, if indeed technology is costly, as I try to think through your very interesting question, is there may become a greater push for the legal profession to actually be able to incorporate. Because at the moment, one real problem that I see for the legal profession is they're not going to even get the advantage of some of this technology because they don't have the capital generally to make the kinds of moves, to buy this technology. And one of the things we see in the most advanced area, which is document discovery, it's not, law firms aren't the only people taking advantage of this. It's business. And it's not surprising. One reason they have is they have a capital formation advantage, and that actually they can have an IPO, right, and raise money for that. And so that's what I think may be the most important structural way that the law profession, if indeed technology becomes expensive. Now, whether they're still going to do well in this, who knows? One other problem lawyers have is, as any established institution, they're wedded to doing things the old ways, and that's why people often in technology, or the upstarts, win out, because they don't have that legacy of doing things in the old ways. Your last question, what life is going to look like in a law firm, I think one's likely to certainly work among machines. I think one's going to really going to have to be, in some sense, an expert at working in that way. One thing I think, though, may happen is that there may accrue some advantages to some people with simply good personalities who actually can persuade clients to do things that are in their interest. And that is not so obviously correlated with analytic ability. Anyone who's on a law faculty knows that.
John Oliver Goodenough from Vermont Law School, visiting here at CodeX for the first half of the year. I agree wholeheartedly with what you say, but I'm wondering, are you pushing it far enough? For instance, in your vision of machine-generated briefs, one of the Supreme Court justices in Vermont gave me this insight, that the brief is an ordered data field. Using natural language as the means of providing it. Why would we insert a machine to take the ordered data that we're doing, convert it to natural language in a relatively mechanistic way, to be read by somebody and then reconverted back to the data? I think one of the things you're going to see is actually we're going to drop the natural language intermediate step out, send the ordered data in as a data field, and the court is going to absorb it as such and move forward. So anyway, I agree wholeheartedly, but I think that the notion that we're going to be dealing with something that looks like what we currently do, only we've just made it a little faster, isn't the full story we're going to see going forward.
Well, I think again, how fast things are going to change. This is a medium time story for how fast things are going to change in 30 years. That may be right. I think implicit in your question is this very interesting question of, well, if we're just making the best prediction of what the law was at any time, could computers replace judges themselves? Where I would see that actually beginning would be actually in arbitration. Because if indeed it turns out that one could have a machine that gives us a more stable, that both parties, I think, are going to think is going to make a better prediction of the intent of their contract, I don't see anything even in existing law that wouldn't allow them to resolve things. So I do see things, maybe some rather wild things possible in the future, and that would be an example of one. And I even see a pathway through arbitration to see how that could begin.
Yeah, Micah Siegel from C2C Patents. We're a Stanford-based economic consulting firm that does damages analysis. I'm really curious to know your thoughts, if you have them, on the way machine intelligence might affect our practice of building economic models to opine on the value of alleged infringement. As they get more baroque and more complicated, is there going to be a escalation of economic models driven by machine intelligence, and where's that going to go?
Well, I can say that at Northwestern, I'm working at the moment with a graduate student and someone in the engineering department on trying to come up with a structure in which we predict the likelihood of likelihood of the patent would be challenged in any particular way. And you're right, that depends on a variety, not only, and I think it's important to understand always, let me just step back here, that when we talk about big data, data isn't enough. You need to have hypotheses. You need to have models, and I think that's what you're talking about. But I see that as a competitive enterprise. I mean, I'm sure other people are thinking of a structure, a model to use with the data. Now, happily, one can get data from things like Lex Machina, structure generated here. And I see a competition in that respect happening. So I'm not worried if what I heard in your question was we're going to have this proliferation of models. We have a lot of lawyers now as well, and people try to decide who's going to better represent them, who's going to make the better predictions. I think we'll do it in a more dispassionate way, even if we have competing models.
Hi there, I'm actually a 1L, and this is sort of dovetailing with your last answer, but I used to work as a data scientist, and one of the challenges that sort of we've always had was that actually without industry knowledge, it's extremely difficult to actually build this stuff in practice. And so I guess the framework of setting out the technology is something external is going to come in and disrupt everything sort of makes me wonder why it has to be from the outside. I mean, it seems like without the industry knowledge, this could not happen. And so it seems like something that would occur from the inside with lawyers learning how to code, like learning math and then doing this on their own. So I'm wondering, like, why isn't this just, lawyers like learning a new skill, like math, and then just, expanding their operations that way? Because as you said, without models, without hypothesis, data really isn't good for anything.
Well, I think you raise a really interesting question about the future of legal education, right? Where is this going? Where are we even going to train people best? And one idea, you make an absolutely excellent point that we have a lot of legal knowledge in law schools. On the other hand, we have actually, I think you're an exception, a lot of people who are not very enthusiastic about mathematics and not very enthusiastic about data. In comparison, we have in business schools people who are quite enthusiastic about data and at least more enthusiastic about mathematics and models. So I think that's a question, but I think your question really goes to the heart of how do we marry data analysis with the kind of knowledge that you need to build hypotheses and models. I think that's what's going to happen. I'm sort of enthusiastic about that happening at law schools, but I think law schools would have to be a little more visionary, perhaps, than they have been in doing that. I know at our law school we are starting, there are two ways of doing that. One is to try to bring in more of that information for JD students who like it, more statistics, more. Or another way is to have a sort of master of legal science who bring engineers and put them into the law school environment. And I think that's an alternative way of doing this, and we're trying that latter way as well. And I think that, again, I'm for competition, and I think probably both ways have some merits to them.
Thanks for a fascinating presentation. I'm Scott McLeod. I'm the founder and president of World University and School, which is Creative Commons licensed. We'd like to have law schools in all 242 countries if we can. I was glad that IBM Global University Director Jim Sporer recently said that Watson had added a whole language sort of indexing approach, and they're developing approaches to legal cognitive assistance, for example. I'm curious, you mentioned the relationship between sort of drawing on England's codification of standards and coding. I'm curious interlingually, your anecdotal understanding of how law and machine learning will affect sort of the legal profession and even questions of justice. So, we would like to be in all 242 countries in multiple languages as law schools using AI. What implications do you see in this very early form for the interlingual practice of law and these AI developments?
Well, that's a question I haven't given a lot of thought to. One thing I would say about this, I would analogize it a bit to smartphones. One of the tremendous advantages of smartphones is that they really allowed less developed nations to leapfrog sometimes and to have tremendous advantages, to have markets, to know what the prices are. Smartphones have had I can't give the statistics, have had a hugely important effect on the GNP of those nations. I do think one advantage in general of this technology, as with respect to other technologies, may be to allow some other nations which already have a rule of law system, because they need to have some institutions in place, to catch up in some sophistication. In other words, to catch up in the predictability of law. Because even if you have a rule of law, in other words, you don't have a situation in which people are simply handing out arbitrary justice, you still need a lot of different institutions, a legal profession, an administrative structure, to predict what law is going to be. And so maybe I would hope that the technology would help some of those poorer nations do so a little faster than they otherwise would, with the analogy that I think that smartphones have very much helped GNP growth and create a certain convergence in those nations.
Hello. My name is William J Lotz. I was involved actually in building the internet and many of its technologies, and I was also involved with the early work on developing the economics of the internet. And Hamburg and Quest studied disruption in general and how the network was going to affect and how technology was going to affect things. And believe it or not, there were early efforts to drive legal information systems early on, and they all failed in rather miserable ways to begin with. And one of the things that was discovered along the ways of doing this was that you had to have economic engines that could evolve and be brought in and increased in terms of complexity and have competitive compounding, so to speak, that would cause the kind of transition that you've spoken about to happen. Now, right now, there are different ways of taking things forward. From an economic perspective of scaling an existing practice, perhaps one that is done with a very high face value to clients, or possibly one that has skill that can be greatly magnified in terms of scalability. Those are ways that you would go from existing practices back down to get a larger customer base that is used in a greater discount with regard to the existing practice they would otherwise receive. That is one model of going forward. Another model of going forward is the cost for having courts in each of these vicinities is extremely high. There are a number of areas where we can't get court dates, we can't have enough justices, we can't process enough jurors, various reasons. Those are costs to a society that have direct impacts on whether or not you can have reasonable justice in reasonable time. And that would imply something along the lines of standards that would have to fall in place so it makes more efficient court systems and more provable jurisprudence, like you were referring to in the later part of your talk, more valuable. There are different models, in other words, for going forth. But there is no clear model as to how we get to one of those various models, or possibly one I have not yet described. That is really, I think, more or less the critical issue here. And some of the other questions asked today hinge upon those different models and whether or not one goes forward versus another. Do you have any view, any opinion as to how you would see the threshold being reached here, such that it's not just a technology that helps and then has an economic barrier, such as certain discovery technologies that are being used by multinational corporations very effectively, but they don't have a competitive environment because of the scope of how they impact is very narrowly served for their market?
Well, here's my view. I mean, I think we'll see competition, as you say. It's beginning with large law firms that can invest in the predictive algorithms. But one of the striking things about technology, if we're talking about access to justice and using these matters even in not with multinational corporations with millions of things at stake, is how cheap technology becomes quickly, right? I mean, the striking thing in all this discussion of inequality in our nation is you go back 100 years ago, how long it takes for someone to get a refrigerator, for refrigerators to become common. Today, it takes less than a decade for smartphones to become common. So I'm quite confident that once this level of computation has been reached, and given that we have a competitive system of lawyers, that they will use these as inputs, and once the technology is used, it'll become less expensive and then will be more broadly diffused. So I understand, I don't think this can ever be imposed, computation from a top-down perspective, but because it now, I think, is cost-effective, our competitive model will use it, and then as in other areas, the fruits of that will be distributed quite broadly.
Hi, my name's Eric. I'm a second-year student here. You sort of hinted on your last question, but I'm curious if you could expand on it. A world in which lawyers are required by their ethical requirements to engage in some type of computational analysis. You can imagine if a computer can really accurately model something or assist in writing a brief, a world in which it's malpractice to not engage in that type of technology if it really will add value or efficiency for the client.
Oh, I think that's absolutely, I certainly can imagine that world. And I can imagine that world not only with respect to law, I can imagine that world with respect to medicine. Now, let me be clear here. Maybe I haven't been as clear as I should in this talk, because I think that question allows me to talk a bit about this. I'm not saying lawyers are always going to be replaced. It may often be that the combination of a machine and a lawyer will be better. Well, even now, the combination of having LexisNexis and then that I think will continue. Maybe the relative inputs will change. And there's some indication of that from technology as well. Even though the best computer in the world can now easily beat the best grandmasters, it remains the case that at least with good chess players, that if they have one of the best machines, they can beat the machine. In other words, there still is some valuable input that humans are giving. And so I think while it may be malpractice to not consult the computer in many cases, at least in some cases, at least in some high-value cases, it will continue. It would be malpractice simply to rely on a machine as well.
Any questions there?
Hi, I'm from Chile. I'm in natural language processing for processing complaints, and we're thinking of targeting this market, so helping lawyers to do smart search. There are two things that I am not sure. One is, how does the thing that lawyers charge by the hour is preventing to be more effective in terms of using technology? Since I have the same task, but I can do it in 1 hour, or I can do it in 10 hours. How this is in the equation? And what have you seen as best practices in using technology for search, legal search?
Well, I'm not quite sure I understood the best practices. I mean,
yeah. So it's commonly used nowadays in lawyers to use this type of technology. Yes. And how it affect the productivity of the lawyers? Do you think in terms?
Well, I think it will. I mean, it will increase their productivity. In some sense, that's the same answer to your first question, which is, of course, lawyers can charge whatever they want an hour, but in a competitive market, they're not going to be able to charge that if people can go to a machine and have a lawyer do less for it, right? I mean, they have to ultimately, in a competitive market, can charge the marginal product of their services. And so lawyers' billing rates, already we're seeing that lawyers' billing rates really aren't their rates. They discount them. There are auctions that general counsels do. I think we're likely to see more of that. And one other thing that's going to happen, and is already happening, I discussed this with a general counsel in Chicago, and she said one of the great things about being a general counsel now was they could have a much better tabs on what their lawyers are doing at all times, right? They got the data of what their outside lawyers were doing, and that allowed her to be much more efficient. In other words, it reduced the agency costs of outside lawyers. So, and was very good for the companies, maybe not so good for those lawyers.
Any final question for Professor McGinnis? All right.
Yes. Hi, Professor McGinnis. So what you've described with data analysis and analytics and compiling lots of data over time is very helpful to predict, as you can say, whether a patent ought to be challenged or in litigation overall. But within the corporate context of drafting documents, I can imagine that aside from just filling in blanks, which there are already programs who do that, it would be very helpful as a transactional lawyer, as I'm drafting contracts, to know what exactly is market, how successful this has been in litigation in the past, and what some of the, if I put this word in here or there, how does
What's
that affect?
happened, right? Connect up and it won't surprise you to know that there are companies, startup companies that are doing that. A company called Kayak, I think it's changed its name, actually was doing that with respect to contracts, but mapping actually what are the results of these various provisions and what has happened to them as they're launched onto the world of law, I think is going to be absolutely important. So I like that question. I should have emphasized that there should be a separation between the data about transactional documents and just helping you generate them, which I think is going to be important, but then in tracking them through the course of the world. And then that has a feedback effect on what am I to use here, which is going to be based on real knowledge rather than the kind of intuitions that some senior partner has, which I'm sure are not unrelated to what he thinks has happened in the world, but don't have that kind of strong evidentiary background. So I absolutely think that not only will happen, it is happening.
Sorry, just a quick follow-up. Would privacy concerns somehow enclose the how well it's going to work? Because I know not all contracts obviously are out there in the world. A lot of things are confidential. And so do you only employ this technology within contracts that your firm has done? Can you somehow strip the information and or at least the names of the parties? And so how would that
I think those are
work?
all questions that are going to be focused on. One thing I would say is that you make a good point generally. That not all settlements, for instance, your point could be generalized, are available to people. And so it doesn't mean we're necessarily going to have perfect predictions. We don't know all the settlements. We'll have less information. But the question, of course, isn't are our predictions going to be perfect? Are predictions going to be as good as they can be given the information we have? And I still think the kind of data analytics and legal predictive analytics will help us with that, given the information. You're quite right. There are constraints on the public nature of information, although, of course, as well, we think, often with litigation and things, that we should have of precedent that's public precisely because of its public regarding nature, because it helps people predict. But I don't think anything I've said depends on all legal information being public. Some of it will continue to be private because people will have the right and the interest in keeping it private.
All right, well, if there are no more questions, then please join me in thanking our speaker.